Welcome back to the Bloggerian channel. Today we are evaluating two seemingly contradictory and potentially controversial decisions by the Supreme Court of India concerning PSB bank retirees and the principle of one rank, one pension, OROP, a status that judges recently granted themselves while denying the same in the form of pension updation to bank retirees. I am Priya Chakraborty and my co-host is Anil Agrawal.
In the case Re-ReFixation of pension of ex-judges, the Supreme Court of India ruled that retired High Court judges form a single homogeneous class and are entitled to a uniform pension calculation, effectively a form of OROP, irrespective of their prior service in the district judiciary. An interesting situation given that bank retirees' demands for parity, OROP by another name, has reached an impasse in the courts.
Very interesting. By the way, this was not a retired judge suing the government. This was a Suo Motu action.
Meaning the Supreme Court started the case itself.
Our mission here is to discuss and critique what some of our sources are calling a jurisprudence fault line. We're going to do that by comparing two major court decisions on pension parity.
And if you've heard the term one rank, one pension, or OROP, especially with the military, then you already know the basic idea we're talking about, which is pension parity.
Exactly. It's all about trying to link retirement benefits to current salaries and ranks so retirees can beat inflation and live with dignity.
And this is where the paradox really kicks in for you, the listener, because we have this really striking situation. On one side, the judiciary, through its own legal action, secured a type of OROP, or parity for retired High Court judges.
Okay, for themselves.
Yes, for themselves. And then a separate group, retired public sector bankers. They demand essentially the same thing as High Court judges, parity, or OROP, and they were just flatly denied.
So, that's the puzzle we're trying to solve. Did the judiciary basically find a way to grant itself a privilege that it decided was too expensive or maybe just legally impossible for everyone else, notably bank retirees?
That is the central question. Pension updation is just an attempt to maintain the buying power of your pension by linking it to what current employees are making. To understand why one group got it and the other didn't, we have to look past the money.
And into the legal arguments.
And specifically, into the constitutional arguments that were only available to the judges.
Okay, so let's start with the successful High Court judge's case.
Right.
The one where the judiciary was accused of protecting its own. This is the case in a re-refixation of pension of ex-judges.
And the way this started is so important.
Yes, the court initiated the proceedings, Suo Motu, to fix what it saw as a problem within its own institution. That's a huge move.
It tells you everything. It tells you the court saw this as a matter of structural integrity, not just some employee benefit dispute.
So what was the actual problem they were trying to fix?
Well, the anomaly involved judges who were promoted from the lower courts, the subordinate judiciary. Because of how their total service was calculated, these judges, after retiring from the High Court, could sometimes end up with a lower pension than a district judge who never even made it to the High Court.
Wait, so you get promoted but you end up with less money in retirement. That makes no sense.
Exactly. It completely undermined the dignity of the higher office. So the Supreme Court's big ruling, its holding, was that all judges who retire from a High Court are one single group.
A single homogeneous class.
So, it doesn't matter if you were a lawyer from the bar or a judge from the lower courts before that. Once you retire from that constitutional post, you're all the same.
And how did they legally justify erasing that distinction? What was the tool?
Article 14. The right to equality. The same argument regularly made by Counsel, acting for bank retirees. Citing Article 14, the court basically said that distinguishing between two people who retired from the exact same constitutional office, regardless of their career path to get there, is arbitrary.
Okay, I have a question. How are these judges different from bank retirees, who in their own way are a homogeneous group of people?
Prima facie. I don't see a difference. But then I'm not a Supreme Court justice.
The justices said it lacks an intelligible differentia.
Right. Which in simple terms just means the government needs a good, non-arbitrary reason to treat two groups differently. And here, the court said there is no good reason, not once they've retired.
So the whole point of making them calculate service as a notional single period wasn't just about the money.
Not at all. It was explicitly to uphold the dignity, the independence, and the uniformity of the judicial office itself.
This was about protecting the institution.
The institution. That's the key takeaway. It was framed as a constitutional necessity to protect a co-equal branch of government.
Okay. So now, let's switch gears completely. Let's talk about retired bankers. The case is MC Singla v. Union of India and other similar cases since.
A totally different outcome.
A totally different story. You have retired public sector bank employees, and their argument is, it's very practical. Their fixed pensions are being eaten up by inflation over the years.
Of course.
So they're demanding updates that tie their pensions to the much higher salaries that currently serving bank employees in equivalent roles to theirs are getting.
And you have to remember the scale of this. We are talking legal principles, but this affects potentially millions of retirees facing real financial hardship.
But the High Court comes in with a totally different legal lens, and this is really the death blow to their case.
It is. The court held that retired employees and active employees are not a homogeneous class. They can't be treated as the same for pay parity purposes.
That feels like the fundamental difference from the judge's case. Can you walk us through that distinction? Why is a retiree legally different from a current employee?
Well, it all goes back to a huge precedent, the DS Nikhara case. Now, Nikhara was a landmark because it established that the government has to treat all its pensioners equally amongst themselves.
Right? You can't just pick a random date and say people who retired before this get less.
Precisely. That's what we call a horizontal comparison. Retired employee A versus retired employee B. The law says you have to treat them the same.
Okay, so the law demands uniformity within the group of retirees.
Yes, but what the bankers were asking for was different. They were demanding a vertical comparison.
Retired employee versus an active employee.
Okay, and the court said that's impermissible. An active employee is getting paid for work they are doing right now. Their salary reflects current living costs, current responsibilities. A retiree is getting paid deferred compensation for past service. Their situations are fundamentally different.
So by asking to link their pensions to the active payroll, the bankers were kind of walking into a legal trap.
They were asking for something that goes against the established legal definition of what makes two groups different. Courts saw a very clear, rational reason to treat them differently. One is working, the other is not.
While it's true that Counsel for Retirees have linked the pay of active and retired bankers to argue for updation, the vertical distinction ruling does not address the fact the PSB retirees are treated differently from their RBI cohorts.
True. And this is where you see judicial modesty kick in. The court basically looked at the massive unquantified financial cost of ordering this nationwide and stepped back. It said, this is complex policy decision.
And that's a job for the government, not for us.
It's for the executive and parliament to figure out, not the courts.
So this really brings us to the core of it. The whole idea of a homogeneous class seems to be the key that unlocks why we have these two completely opposite outcomes.
It's all about the direction of the comparison you're making.
Okay, can you be clearer?
Yes. In the judge's case, the Supreme Court did a horizontal analysis. Retired Judge A versus retired Judge B.
And it said they're the same, they both retired from the same post, they must be treated the same.
Okay, they essentially created that homogeneity by judicial order to protect the dignity of the institution.
And in the banker's case?
That was a vertical comparison, retired banker versus active banker. And the court said, no, absolutely not. These are two different classes defined by whether they are currently in service.
So legally speaking, turning down the banker's request was actually consistent with the law.
Yes, consistent with precedent on economic policy and classification, but a violation of Article 14 nonetheless.
Well, if we stop there, we miss the most interesting part, because even if the banker's case was correctly decided, the judge's case, that was an assertion of power that, no one else has.
Absolutely. And this is where we have to talk about the judiciary being sui generis.
A unique class of its own.
Okay, the judges weren't just fighting for a better pension plan. They were fighting for a core constitutional principle, judicial independence.
Explain that connection. How does pension money connect to independence?
Well, the idea is that a judge should never feel financially dependent on the government, not during their career and not in retirement. If their retirement isn't secure and dignified, it could, in theory, make them vulnerable to pressure.
I see.
So, ensuring a uniform, dignified pension protects them from being compromised. It's a constitutional shield that a bank employee who is governed by contracts and statutes simply doesn't have. The judges are governed by the Constitution itself.
And that really shows the two different hats the judiciary can wear. The judge's case, which they started themselves to fix their own problem, that feels like textbook judicial activism.
A perfect example. The court saw a problem in its own house and it fixed it.
Whereas the banker's case, where the court refused to get involved, is a massive financial policy matter.
That's classic judicial restraint, deferring to the executive branch. It's the same judiciary operating at two different ends of the spectrum. And it seems the constitutional status of the person asking is the deciding factor.
Okay, let's bring in an outside view here because I think a lot of people listening might be feeling a bit uneasy about this. Let's take an example from the United States.
It's a really useful comparison. In US law, they have something called rational basis review under the Equal Protection Clause. It's very similar to India's Intelligible Differentia test.
And the banker's case,
The MC Singla decision denying parity between current and retired staff. It would almost certainly survive a rational basis review in the US. It's a fiscally sound, logical policy choice.
but the jarring part, as our sources puts it, is the Supreme Court basically wrote legislation for its own financial benefit while telling everyone else, sorry, too expensive.
And that's the unavoidable appearance of a conflict of interest. Even if you justify it with the high-minded principle of judicial independence, it still creates this appearance of self-dealing.
Right?
It makes you ask the question, is the judiciary a neutral referee for financial rules, or did it just create a special, more favorable set of rules for itself? It really blurs the line between judicial and legislative power.
It's the court saying its own institutional needs are constitutional necessities, and those necessities outweigh the very same financial concerns that stop every other group's request.
That's it in a nutshell. The court effectively said, our structural independence is of a higher value than the fiscal prudence that we cited in the bank retirees case. It's a value judgment made from inside a constitutional fortress.
So to sum this all up, the two judgments, as weird as it sounds, are technically legally consistent within India's framework of defining a class.
A major leap of logic. At least, Counsel for retirees now know which rabbit hole to avoid.
But the judge's case is a clear policy choice, a value judgment that the judiciary made because of its unique position in the Constitution. It carved out a special exception for itself.
Exactly. The judiciary, through some very careful legal reasoning, has essentially declared that the dignity of its office requires a level of equality for its retirees that is just not constitutionally required for anyone else.
It's been a fascinating discussion, and it shows how being put in the right class can be everything in a courtroom.
And maybe here's a final provocative thought for you to take away. If the whole reason for the judges' pension parity is to guarantee their independence and dignity, what about other public servants?
What do you mean?
Well, think about roles that also rely on absolute structural impartiality. High-level regulators, the head of the central bank, maybe the people who run the election commissions. Should they also be considered sui generis enough to get similar court-ordered protections for their retirement, or is that special constitutional shield reserved only for judges?
A question that connects independence directly to the wallet and to the very structure of government.
Thank you for watching. Please share, like, comment, and subscribe.